Hey, Paul, this is me checking to see if you can hear me in 121. You could text me and tell me that you hear me, or, you could come out and give me a thumbs up or something. But I'm just going to keep talking into this mic until I get some kind of indication that this is all working. Yeah.
Good evening, everyone. Good evening, everyone, and welcome. Welcome to the 2024-2025 Moot Court Competition Finals. This annual competition is named in honor of Sherman Minton, an Indiana native, Army veteran, jurist, and a 1915 alumnus of our law school. He served in the Senate as a judge of the Seventh Circuit of the Court of Appeals, and from 1949 to 1956, as a justice of the United States Supreme Court. In his short tenure on the court, Justice Minton was involved in some of the most important post-war cases. He was noted for his broad view of government powers and for his abhorrence of segregation, which was demonstrated by his vote to strike down Brown v. Board of Education. The Moot Court competition involves more students than any other single activity at the law school. This year, 70 second-year students competed, collectively writing 35 briefs and giving nearly 200 oral arguments throughout the competition. Such a large number of competitors requires the involvement of a significant number of alumni, of faculty, and of staff, and their devotion is definitely noted. We are grateful to all who volunteered their time and their wisdom to help serve as judges. Their commitment to this program is truly essential to its success and to the quality of the learning experience for all of our students and our participants. We will hear oral arguments tonight from the 4 finalists who emerged from a very strong field of competitors. I want to say ahead of time, congratulations to the 4 of you. Kyla Befaruz, Lily Rutledge, and for the petitioners, and Braxton Miltenberger and Laura Stancato for the respondent. Before we begin, though, I have a number of special thanks to a number of people for supporting this competition. First, I want to thank the Moot Court Board and executive board members for pulling together a wonderful competition. These students have made a tremendous commitment of time and energy to the endeavor, to the benefit of the school, and to the competition participants. Thanks are due also to the board's faculty advisor, Professor Lane McFadden, for his invaluable support, not just of this competition, but really for this aspect of our school's curriculum is just remarkable. And his guidance throughout this competition is, to say it's invaluable is to understate it. And also to Professors Ryan Scott and to Cindy Cho for their assistance in developing and revising the problem. To Associate Dean Steve Sanders for coordinating our distinguished panel of judges tonight, and to Professor Stake for his guidance on scoring. I'd also like to acknowledge Dean Gabriel Escobedo for his efforts supporting community and inclusion around this year's competition. This competition could not be done without the tireless work of our outstanding staff members, and thank you so much to Chelsea Browning and our events team for their work coordinating this event, and to Marion Connedy and Paul Stiles for their expert audiovisual assistance. Finally, I'd like to thank and congratulate all of the participants in this year's competition, and most of all, to thank all of you, the parents, the family members, the partners, the friends, and the finalists who are here tonight to celebrate this great achievement. With that, I will turn the podium over to Ryan Day. Ryan is the Chief Justice of the Moot Court Executive Board, and he will introduce this year's judges. Thank you very much, all of you, for joining us tonight.
I'm not going to let Ryan speak before me. No. Hello. All right. Thank you, Dean Ochoa. I'm really excited to see such a packed house for tonight. This is sort of the Super Bowl of the law school year, and I think it's fitting that we're all here. I mean, for the competitors, obviously, this is a real achievement and a great pinnacle of the second year of law school, but I'd like to think of this event as a way to celebrate the law school community at large. I mean, Dean Ochoa gave some impression of the great scope of how many people it takes to get this thing to happen. This year we had 214 different people who were directly involved in the competition. Obviously the stars are the 72 Ls who wrote briefs and gave the oral arguments and competed. I'm happy to see a lot of them here tonight. Obviously our 4 finalists, but a lot more competitors here in the room. We also had some, and I have to check my notes, 27 volunteer bailiffs from the 1L class and a few from the 2L class who just gave of their time freely to make sure that the rounds ran smoothly, that people got where they were supposed to go so that they could watch and learn a little bit. And we really genuinely could not have done it without those folks. And I especially want to emphasize how valuable the contributions of the 3L class are. We have, between the competition board and the executive board, 35 different people who worked for a full year to make this competition what it is. And I think it's important to realize that all of what you see here is student work. The problem itself is written by students. If you weren't competing, you didn't get to see the full problem packet. There's photos of the crime scene. There's an audio recording of the dispatch call. There's police reports. The whole thing is really cool. It really brings this fake case to life, and that is all a student creation. The students are the ones who reach out to our faculty, to members of the bar, to members of our alumni, to get them here, to have them judged, to make sure that the students are well and fairly judged. And they do that managing an incredible amount of logistics over 5 weeks, both virtually and in person. It really is an incredible amount of work. Multiple 3Ls read every single brief that the 2L competitors wrote. And in the fall, on top of all of that, they judged over 200 practice arguments during appellate advocacy just to make sure that folks felt like they had been prepared for this experience. So I really would just love to have a round of applause for those 3L members of our boards. We have something really special here in the advocacy program at Maurer, and I'm really proud to be a part of it. And a big part of what makes it so special are the amazing lawyers who give so generously and freely of their time to judge these rounds. This year, 82 different members of the bar judged at least one round of this competition. And many of those folks judged multiple times on different weeks. And I mean, to say we couldn't do it without them really undersells the value of that. The fact that they are willing to leave work and drive down to Bloomington on a weeknight shows how much they value the moot court experience and how important it is to them. And I hope that makes us realize how valuable it can be and important for us. Students tell me when they do this competition, the 2 things they get out of it most are, of course, number 1, getting over their fear of public speaking. That's the big one. But number 2, it's the feedback they get from real practitioners where they actually get to interact with people who tell them directly, this worked and this didn't work. And the students really value that. And the feedback that they get is really valuable because of the quality of our alumni, the members of the local bar, the members of our faculty who judged, and members from the bench who came to judge these rounds. And so it really is incredible to see the community coming together to support this activity year after year, and this year was certainly no exception. So now I'm done, and now, finally, having waited patiently, our school's favorite Purdue fan, Chief Justice Ryan Day.
If there are other Purdue fans, you're my favorite Purdue fan. So thank you, Dean Ochoa, Professor McFadden. Good evening, everyone. I'm gonna pace you guys here. All right. Good evening, everyone, and welcome to the 59th Annual Sherman Minton Moot Court Finals. It has been my distinct honor to serve as the Chief Justice for the 2024-2025 Sherman Minton Advocacy Board. For the last 9 months, since last summer, our board has been designing, organizing, and running this competition. And it's not just the largest event in this law school. It is one of the largest primarily student-run moot court competitions of its kind anywhere in the country. It really is something very special that we have here at Maurer School of Law. Needless to say, an event of this magnitude would not be possible without the support of so many people, including many of the people in this room. And if you'll let me, I'd like to recognize some of them now. First, I'd like to thank our competition board. The competition board consists of 3L students who have a passion for advocacy. These individuals have done a tremendous amount of work over the course of the semester, grading briefs, judging trial competitions, serving as bailiffs, and many, many other things. They also were some of the people who handed out programs to you today. They really know how to step up whenever they can. They've truly made this competition as a whole seamless. And so for any of the members of the competition board here today, would you please stand to be recognized? So next, I'd like to recognize and acknowledge the contributions of each member of the advocacy board individually. If you could, please indulge me and stand while I recognize you so everyone can see you as I talk about all the great things you guys have done this year. So our problem coordinators, Noah Giedemann, Emma Leonard, and Raven Vance. These 3 individuals wrote the problem that you will hear argued tonight. The problem coordinators started brainstorming ideas for the problem way back in June. Since then, they have poured countless hours into writing all the record, opinions, and materials for the competitors. The credit for this year's incredibly detailed, creative, and balanced problem is owed to them. These 3 are undoubtedly some of the most intelligent, dedicated, and thoughtful people that I've ever had the pleasure of working with, and I'm really glad that they were on the board this year. Not to single them out, but if we can hold the applause till the end of the advocacy board, just so it flows a little faster, promise. Our judge coordinators, Serena Bolden and Emma Massa. These 2 individuals sent hundreds of emails and made even more contacts to recruit fantastic attorneys and judges into our competition for each of the rounds this year. They were directly responsible, and I went back and counted, for 573 ballots of feedback that competitors received over the course of this competition. Thank you for being the always personable and professional face of the recruitment for this competition. Our competition board coordinator, Brooke Harden. Brooke recruited and managed the 3L members of the competition board. She ran a tight ship. Anyone who knows Brooke knows that's an understatement. She trained all of our bailiffs and brief graders and made sure that all the 1Ls and 3Ls who contributed to the competition got their work done timely and with excellence. Our advocacy coordinator, Sam Downton. Sam was responsible for organizing all of our other competitions over the course of the year. Some of the people in this room, especially the audience members, the family members, might not know this is not the only competition that we run at this law school. We also have trial and alternative dispute resolution competitions, which she ran with unmatched expertise and grace. She was also the point person for organizing moots of our external moot court competition teams, which we had several of and several successful ones over the course of the year. And she truly raised the bar for how the advocacy board supports the external competition teams here at Maurer, and for that we thank you. Our communications coordinator, Claudia Eder. Claudia helped recruit and communicate with all of our 2L competitors and kept everyone apprised of the competition's progress through our social media. Our logistics coordinator, Annie Hudacek. Annie was a pro at the blocking and tackling of running events of this size in this school. She was key to scheduling competitors, booking rooms, ordering everything needed for the competition, and especially the food and the soda, which is huge. Our scoring coordinator, Kyle Pobans. Kyle was our in-house Excel wizard. Kyle got into the nuts and bolts of our scoring system this year to understand how the systems work, and was always thinking at every stage of the competition about how to promote fairness among the competitors to make sure that we had the best results for our students. The three of you help keep this competition running day in and day out. Your commitment and flexibility have been a godsend, and I cannot tell you how much I appreciate your contributions. Last but not least, certainly not least, my rock throughout the past year, our Associate Chief Justice, Allison McDevitt. Allison's contributions to this competition and all of Mauer's advocacy competitions have been innumerable. She has helped me lead in every facet of the competition. Pretty much anything that goes out the door has benefited from her input and feedback. She is patient, sensitive, and an incredibly hard worker, and she is always thinking one step ahead to anticipate any challenges down the road. I am a better leader for having led this competition with you, Allison, and for that, I thank you. The leadership team has been awesome, but I can assure everyone that next year's will be in just as steady of hands, because I'm thrilled to formally announce that next year's advocacy board will be led by the next Chief Justice, Mr. Jackson Higgins. I have a few last thank yous to add before I get out of the way and leave you to tonight's feature presentation. I promise I'm going to get through these as fast as I can. I second all the thank yous that Dean Ochoa and Professor McFadden already said, to Associate Dean Sanders, to Marion and Paul, to Chelsea, to Professors Scott and Cho and Stake, to Dean Escobedo, and to everybody in this building who helped make today a reality. While he couldn't be here today, I would like to add one additional recognition to an alumni of this school, Mr. Jamie Sutton, who is also the recipient, or will be the recipient, of our Outstanding Judge Award, in recognition of the countless hours that he spent over the past year, both during the Sherman-Minton competition and the trial competitions, supporting, judging, providing feedback. He really went above and beyond for all of the competitions that happened within this school today, and we're really lucky and thankful for all of his contributions. And so, to Jamie Sutton as well, wherever you are. We could not have put this competition on without the knowledge and support of our faculty advisor, Professor McFadden. I'll add one more personal thank you to him. He made himself constantly available to us day and night, weekday and weekend, to help with every aspect of the competition. Mauer's advocacy programs would not be the successes that they are without Professor McFadden's dedication to the cause. I am thankful for all of your help and for everything I've learned from you over the past year. So, thank you. All right, enough thank yous. All the hours spent by the board preparing and working were made worthwhile by our competitors this year. Over the past few weeks, the board and I have gotten to watch the competitors give their all to this competition and develop both their skills and passion for doing this kind of work. We have been so impressed by your dedication and spirit, and when we started, we could not have envisioned the heights of advocacy that you all have achieved. We're now down to our final 4 competitors. Double checking. We're now down to our final 4 competitors. These competitors have continuously impressed us round after round, and I know they will impress you all tonight as well. Our competitors seated in front down here are Kayla Befarus, Braxton Miltonberger, Lily Rutledge, and Laura Sincato. Before we begin the final round, we would like to honor the top 32 competitors as well. These competitors excelled in brief writing and their oral argument skills. And for those of you here in the room, if you would please stand and be recognized as well. All right. Now, before we welcome in our judges, a brief bit of context for those of you who maybe haven't seen a Sherman-Minton round this year, or some of the family members who maybe don't know what an oral argument round is. A little bit of context of what you're going to see here today. The 2025 Sherman-Minton Moot Court problem challenged competitors to explore pertinent Fourth Amendment issues in the context of a high-stakes police encounter, presenting a complex legal dispute regarding the use of deadly force by law enforcement and its implications for constitutional protections and policing standards. You will hear our first two competitors make policy arguments about what standards police officers should be held to. Next, our second two competitors will make arguments applying those standards to the police officers in this case. After the competitors argue, the justices will deliberate and choose the best two oral advocates regardless of side or issue. While the judges deliberate, there will be refreshments in the lobby that I hope you all will take part in enjoying. Now, we're going to convene the court and we get off the stage. So I want to give one last thank you to all of you in this room, no matter what your contribution was to being here, to getting people here. I appreciate everything that you've done. And this school owes you all, whatever role you play, an incredible debt of gratitude. And so I hope you enjoy tonight's competition. Thank you.
Session. All persons having business before this court, draw near, for the court is now in session.
Please be seated. Good afternoon, everyone. I'd like to call our case this afternoon Aziz versus McDonald. Arguing for the petitioner, Ms. Is it Befarus? Okay, please.
Good evening, Madam Chief Justice and Associate Justices, and may it please the court. My name is Kayla Befarus, and I represent the petitioners, Officer Samira Aziz and Officer Harrison Fletcher. Today, I will make 3 points about why the moment of threat test is the proper Fourth Amendment standard. First, it centers the objective reasonableness test on the only consideration that this court has ever held to be dispositive, and that is the threat. Second, it acknowledges that hesitation in these life or death circumstances can be deadly, and it does not penalize officers for acting proactively. Third, it is consistent with its court's precedent. The Constitution neither requires nor allows judicial second-guessing of these split-second decisions that we, thanks to these officers, have the privilege to never have to make. Therefore, we request that this court reverse the 14th Circuit's holding and adopt the moment of threat test. Now, what is that test? First, courts using the moment of threat test look at the perceived threat. They look at whether the suspect had a weapon in their possession, a gun or a knife. They'll look at the distance of that suspect and also the direction of that suspect.
Now, with the moment of threat, would you be able to consider any other circumstances in addition to the moment of threat?
Under the moment of threat
Say
test.
we adopt the moment of threat. Can we consider other circumstances, or we just have to focus on the moment of threat?
Your Honor, you do focus specifically on that moment of threat. And if
Nothing
you're
else
wondering,
matters.
there are factors that matter. For example, the possession of a weapon and the distance direction of the suspect. There are about 5 circuits that use the moment of threat test, and some consider a few circumstances in the moments immediately preceding that are relevant to the officer's perception of the threat in that moment. And some, like the 4th and 5th Circuit, consider only just the milliseconds that the officer uses force. It's our position that this court should adopt today and clarify the moment of threat standard as something that includes the moments immediately preceding and also the moment that threat was used, or that force was used.
Describing that test in temporal respects seems to unduly circumscribe the universe of information that's available to the court or, in an appropriate case, to the jury to evaluate the reasonableness of the use of force under the circumstances. It doesn't tell us anything about the scope of the inquiry beyond the timing question. And that's a concern that I have in application to Justice Young's question. Let's say we adopt this test. What is the universe, what is the scope of the information that a court or a jury can consider with that temporal limitation? You mentioned the issue of whether the suspect was armed and whether the suspect was advancing. I think that's as far as you got.
Yes, and the direction or the distance that the suspect was from the officer. The scope is actually more defined by substance rather than time. It's about what factors, what cues in the environment that the officers were able to pick up on the moment that they apprehended or that they perceived a deadly threat that was immediate. And the immediacy is important. That comes from Graham v. Connor and the line of cases that the Supreme Court has decided.
For example, what if the officers in the universe of information available to them had information, as in this case, that the suspect that they were pursuing had just shot a cop? Is that within the moment of threat doctrine as you're articulating it? Because it has nothing to do with what's going on at the moment, but it is within the universe of information that was known to them. So I'm trying to get a better sense of what this test entails before we even think about adopting it.
The moment of threat test, Your Honor, would not consider that. There are two reasons.
And how is that favorable to your clients?
To our clients, Officer Fletcher specifically had many independent reasons to think that McDonald, the suspect he was apprehending, was a threat. And my colleague will address most of those. But I will also note that there have been circumstances where officers have used a prior threat that the suspect posed, maybe like 20 minutes before, and then use that as justification to later shoot somebody that no longer posed a threat. And that is one of the reasons why the moment of threat test actually promotes good policing. In the Fifth Circuit, we saw a case where that happened, Amador v. Vasquez, where the guy actually tried to stab a police officer and was a threat in that moment. But later, about 5 minutes later, he was 30 feet away, had his hands up in the air with a knife in them, but was unable to use the knife. And it was unreasonable to shoot him in that moment because he posed no threat.
It seems to me that it's in the interest of law enforcement to consider all relevant circumstances, including what the suspect did 5 minutes before the use of force, 10 minutes before the use of force, 15, 20 minutes before the use of force, or even if he had a history on other occasions completely remote in time of aggression against police officers. That happens in the real world in many cases when officers have a history with suspects that they're pursuing, and they know that perhaps the suspect has a history of acting violently against law enforcement. So I'm not sure how this moment of the threat test actually helps your clients or helps law enforcement. And you're arguing law enforcement's interests here, as I understand it, as a policy matter, isn't that right?
Yes, and it is. I would also argue, Your Honor, that in the moment where an officer actually fears for their lives, there's multiple studies that show that they do experience tunnel vision. They block out sounds in their surroundings and they actually zone in precisely on assessing the threat in front of them. In that way, it makes sense to judge them from their shoes. That usually begins in the moment that they perceive a deadly threat to themselves. And that would be the moment where this court and other courts using the moment of threat test should start considering what the officer saw and knew in the objective reasonableness test.
Does the officer have any responsibility to try to de-escalate a situation?
The officer's responsibility to de-escalate the situation is usually dictated by police policy and is outside of the scope of the Fourth Amendment under the moment of threat test.
But counsel, does your test take into account at all, under any circumstances, an officer's conduct?
That precise issue is not at issue here because the officers did not necessarily create a dangerous situation, or their prior conduct did not do anything to create a dangerous situation by simply responding to one. And I will also note that this court has granted cert in Barnes v. Felix on that precise issue, and it should be perhaps addressed in that case rather than this one. Therefore, we request that this court reverse the 14th Circuit's holding and adopt the moment of threat test. Thank you.
Thank you. Mr. Miltenberger?
Your Honor, I argue issue 2.
I'm sorry. I thought we were going directly to the opposing argument on this first issue.
Yes, Your Honor, that's the argument that I...
Okay, I've got your names inverted on my little cheat sheet here. Apologies. And this is Ms. Stancato. Okay.
Good evening, Your Honors, and may it please the Court. My name is Laura Stancato, and I represent the respondent, Sheila McDonald. We are here today because Sheila's son, Christopher, suffered the loss of his life at the hands of Officer Aziz and Officer Fletcher when they violated his Fourth Amendment right against an unreasonable seizure. The 14th Circuit properly applied the totality of the circumstances analysis in assessing the reasonableness of the officer's force for two main reasons. First, the totality analysis is best in line with the precedent of this court. And second, the totality analysis provides for a better balancing of the needs of law enforcement with the protection of an individual's constitutional rights. For those reasons, we request that you affirm the ruling of the 14th Circuit. First, turning to the precedent before this court. The seminal case in terms of reasonableness and Fourth Amendment seizures is Tennessee v. Garner, in which this court held that the main question is whether, looking at the totality of the circumstances, the search or seizure was reasonable. This was expanded upon in Graham v. Connor, where the three factors that are taken into the consideration of totality are first, the severity of the crime, second, the imminent threat that the individual poses to the officer, and third, whether the individual was evading or resisting arrest at the time that...
It's a lot for an officer to know before he even acts. Now, when does this totality of the circumstances begin?
Your Honor, the totality of the circumstances would begin when the police is first informed of the threat and makes the decision to attempt to apprehend the suspect. We recognize that
Over the radio?
Yes, in this case, it would be the radio dispatch would begin the totality of the circumstances. And that will vary case to case. As we see in police cases like this one, these are incredibly fact intensive, and the facts often vary even slightly, which results in differences whether or not force was reasonable. And the totality analysis, a much broader inquiry than the moment of threat, allows for a much more comprehensive look at what exactly was happening. When we look at just the moment of threat test, as you discussed recently with the petitioner, the temporal region is a bit difficult because you're confined to either the split second or, as articulated in the Fifth Circuit in Barnes, a couple seconds before the seizure. However, the totality doesn't tell you to ignore those moments. In fact, courts, specifically in Scott v. Harris, this court held that that second factor in Graham, the imminence of the threat, is often the most important factor that courts look to. So we don't ignore the moment of threat, we simply look at it as part of a larger picture. We put it all into the context of the totality of the circumstances involving the interaction between the suspect and the officers in the case. And the courts are not limited to just look at these factors. Again, in Scott v. Harris, both Justice Scalia articulated that we should look to whether there were bystanders that could have gotten hurt. And in her concurrence, Justice Ginsburg expanded upon that and referenced de-escalation, which I know was also brought up in conversation. And police officers, whether or not they have the opportunity to de-escalate a situation, that's a relevant factor as well.
No, there's no duty to de-escalate in the Fourth Amendment.
There's no correct, Your Honor. There's no duty to de-escalate in the Fourth Amendment. However, courts, specifically in Scott v. Harris, have looked at that as just a relevant factor. So it will never be dispositive on whether the use of force was reasonable, but it can go to the larger conversation, ultimately resulting in whether or not that use of force at the moment that it was employed was reasonable.
Sounds like what you're saying is after the moment of threat, a few days after, we can all use 20/20 hindsight and say, you know, this officer should have done this officer should have done that. Can you really use 20/20 hindsight in these situations?
No, Your Honor, we cannot use 20/20 hindsight when looking at these cases. Graham v. Connor specifically says that that's not allowed and that we have to take into account the life or death split-second decisions of the officer.
Well, that's the moment of threat.
Yes, that is the moment of threat, which is part of the totality of the circumstances analysis. So the conversation doesn't end there under the totality. While that second factor from Graham is important, it won't be the ultimate deciding factor because you have to look at the larger picture. And that brings me to the understanding of really the key policy here is that this is a balancing test. Courts have to balance both the needs of law enforcement with the protection of an individual's constitutional rights. In this case, a fundamental right that's enshrined in the Fourth Amendment as part of the Bill of Rights. Ultimately, these types of cases end in seizures that often take individuals' lives, as we saw with Christopher McDonald in October.
Well, to that point, actually, I think what we said in the Graham case is that and Tennessee before it, is that the balance is between the nature and quality of the intrusion on Fourth Amendment rights and the governmental interests at stake. Not some sort of generic understanding of Fourth Amendment rights. It's calibrated to the nature of the intrusion. Obviously here we have a shooting, a fatal shooting, so it's the most extreme form of intrusion on individual rights in the context of a seizure. But there are many lesser degrees of intrusion, and that it seems to me needs to be weighed against what was known to the officer at the moment force was applied. In other words, tasing is different from shooting. Taking someone down to the ground is different from putting on handcuffs, etc. So why isn't that exact moment of the application of force the key focus?
That's true, Your Honor. And that really goes to what the officer knew at the time, involves more of an application of the totality of the circumstances. Because we're talking about police officers who have been well trained in this area and are trained to be in situations like these, and everything that happened up until their moment to employ force should just aid them in that decision. The totality of the circumstances test doesn't cut against an officer if that officer was objectively reasonable in their decision to employ force. The objective reasonableness ultimately needs the full context of the situation. If an officer is confined, if a court is confined to looking at the split second that force was employed, they're taking a small piece of the puzzle out of a much larger picture that we need in order to assess the full picture of the reasonableness.
Now, in your totality of the circumstances, certainly the moment of threat is a part of all of that, right?
Yes, Your Honor.
How big a part of that is, of the totality is the moment of threat?
The moment of threat is a large component of the totality analysis. It was articulated as one of the main three.
2/3?
I would hesitate to put a specific number on it just because the facts of each situation will vary so strongly. But that's one of the benefits of the totality analysis, is that courts have the opportunity to look and see. And if something changed in a split second that made threat viable and reasonable, or made force reasonable at that time, then certainly they can weigh that stronger than, say, if the initial crime was not severe.
Have benefits to your approach or detriments. If you have a balancing test where the threat could be a weightier balance, or factor, but need not be, and there may be 3 factors, but there may be a lot more according to some cases. And reasonable minds, we know, can differ, especially when you throw more factors and considerations in. Here's a question. Would we ever be able to grant summary judgment on these types of Fourth Amendment excessive force cases if your rule were adopted?
Your Honor, summary judgment would be able to be granted under this rule, again, if the totality of the circumstances sway or push a court in that direction, so much so that reasonableness was certain in that moment. And in this case specifically, we argue that that's not the case. However, it's definitely not a full stop against summary judgment in future cases. It's again going to depend on the specific facts of the circumstance in front of you and looking at those first three factors out of Graham as a starting point, but then as Plumhoff and Scott have articulated, adding factors as needed. Ultimately, it is a balancing test. It's one that balances two very important interests. But at the end of the day, individuals need to know that their Fourth Amendment rights are not just words on paper, especially when they are faced with law enforcement. For these reasons, the respondents ask that you affirm the ruling of the 14th Circuit. Thank you for your time.
Thank you. Thank you.
Ms. Befrus, I think we're doing rebuttal right away.
Your Honors, I have 2 points to make on rebuttal. Justice Young, to your questions about scope and weight, I will note that the totality of the circumstances test is known to, quote, entangle and be cumbersome to the courts that employ it, because they're never sure, to your point, how much weight to give these factors and even what factors to consider. In contrast, the moment of threat test is much more clear. I will also note that Ms. Stancato said that the threat will not be the ultimate deciding factor. That is not true. In Tennessee v. Garner, this court recognized that it was the dividing line between a use of constitutional force and an unconstitutional use of force. Furthermore, even the totality of the circumstances courts recognize that it is the most important factor and give it proper weight. I will note that there are some courts that use the totality of the circumstances test that do not actually give it the weight that it deserves occasionally, and that ends up with some perverse consequences. For example, in Matos versus Agarano in the Ninth Circuit, there was a woman who was pregnant, dropping her son off at school, speeding in the school zone. When the officers pulled her over, she refused to get out of the car. She didn't attempt to flee though. But they tased her multiple times, dragged her out of her car, put her on her stomach on the pavement. And the officers cited her resistance to arrest as justifications for their force. And they did not suffer any legal liability, but she posed zero threat in that moment. And under the moment of threat test, that case would have come out differently, and it would have resulted in much more just outcomes for everybody. Thank you.
Thank you. Ms. Rutledge.
Good evening, Your Honors, and may it please the court. My name is Lily Rutledge, and I represent the petitioners, Officer Samira Aziz and Officer Harrison Fletcher, in today's proceeding. I will be addressing the second issue in this case, which concerns the police officers' ability to protect themselves and others in life-threatening situations. This court has repeatedly held that police officers must make split-second decisions in tense, uncertain, and rapidly evolving situations. Regardless of the test this court adopts, both Officer Aziz and Officer Fletcher were reasonable in their separate uses of deadly force. Therefore, we ask this court to reverse the judgment of the 14th Circuit Court of Appeals. First, Officer Aziz acted reasonably in her use of deadly force against Mr. McDonald because Mr. McDonald posed an immediate threat to her life. Officer Aziz only fired upon Mr. McDonald when Mr. McDonald fired and shot his weapon at her in the abdomen. Only then did Officer Aziz return fire at Mr. McDonald to subdue the threat to her own life and to others in the vicinity. The 14th Circuit places too much emphasis on any creation of the need to use deadly force. Under the moment of threat analysis, this sort of information is irrelevant according to the Eighth Circuit in Schultz v. Long under this specific test. But regardless of the test that is used, even under the broader totality of the circumstances test, circuits like the Ninth Circuit in Matos v. Agarano have explained that the immediacy of the threat posed by the suspect to the officers or others are most important.
Officer Aziz's use of force is the easy question. Let's get to the harder question.
Yes, Your Honor. So moving to Officer Fletcher. Officer Fletcher's use of deadly force was also reasonable because in light of the circumstances in the dimly lit alleyway, Officer Fletcher reasonably perceived that McDonald was holding a dangerous object and was continuing to advance on both himself and his colleague, Officer Williams, and raised that object in his arm upwards towards the officers. First, a reasonable officer could perceive that Mr. McDonald was holding a dangerous object in his hand. Officer Fletcher identified the object in his hand as a shiny object and also stated that he believed that McDonald was in fact holding a firearm. Although Officer Williams suggests that she did see a cell phone in Mr. McDonald's hand, neither Officer Williams nor Mr. McDonald ever identified that the object in his hand was in fact a cell phone. And as this court explained in Graham versus Connor, the reasonableness of an officer's use of force in a particular moment should be judged from the reasonable officer on the scene as opposed to with the 20/20 vision of hindsight.
Say we adopt the moment of threat. Are there any other considerations that we would take into account in determining the issue of reasonableness?
Yes, Your Honor.
Do we limit ourselves just to the moment of threat?
No, Your Honor, because in the moment of threat analysis, certain circumstances like the suspect's actions, movements leading up to, and the moments immediately prior to the moment force was used can be considered. Additionally, circumstances, external circumstances such as the lighting, the conditions in the environment when the force was used can be considered, as well as the distance to the suspect and any other motions or things that might have led to the officer to use deadly force.
What's the time limit, factually?
Your Honor, there is no explicit cutoff time limit, but under the moment of threat analysis, it is typically limited to just a few seconds, in more rare cases, several minutes. But in this case, the moment of threat would be when Mr. McDonald appears from around the dumpster in the alleyway and when Officer Fletcher could actually perceive that McDonald was a threat to his life and the life of his colleague, Officer Williams.
Why does it make sense to exclude what all of the officers knew, or both of the officers knew in the alley, which is that this suspect had just shot a cop?
Your Honor, while the prior actions of the suspect are excluded from the analysis, the moment of threat analysis also excludes prior threats by the suspect as well as prior actions by the police officers.
Why does that make any sense?
In order to focus on the immediacy of the threat posed by the suspect to the officers or others.
But reasonableness is a holistic concept. It doesn't make sense to cabin it to seconds, a minute, 2 minutes. Those kind of artificial constructs don't map onto a standard as flexible as reasonableness under the circumstances. And reasonableness is the ultimate touchstone in every Fourth Amendment question. So why would we adopt any of those rigid categories? And the facts of this case, from the standpoint of your client, seem to me to suggest that law enforcement would be better off with a broader lens.
In this particular case, Your Honor, regardless of the test that is used, both Officer Aziz and Officer Fletcher acted reasonably in their use of force. But under the totality of the circumstances approach, as the Third Circuit in Abraham versus Rosso explained, some circumstances may be too attenuated to consider in the court's analysis. And by looking at a potentially unlimited amount of factors, this court could err on the side of having hindsight bias or the 20/20 vision of hindsight in its analysis. So in this case, it is our position that the moment of threat test should be adopted, and therefore, at the expense of not looking at the actions of Mr. McDonald firing upon Officer Aziz and about 15 minutes prior, we are focusing on the moment that threat was used in Officer Fletcher's circumstance in just the alleyway. So additionally, Mr. McDonald was still a threat to Officer Fletcher and Officer Williams despite his injuries. He was not entirely incapacitated despite some of these injuries. He was able.
He was mostly incapacitated, wasn't he? His arm was hanging by his side, he's slouched over, he's advancing, but barely. Wouldn't it have been reasonable to use the taser or some less lethal dose of force?
No, Your Honor, because Officer Fletcher knew that he was in pursuit of a dangerous suspect. Right at the beginning of the alleyway, he received a police dispatch notification to proceed with caution that the suspect was still armed and dangerous. And as Officer Williams pointed out in the record at page 26 or 25, that is standard procedure to pursue a suspect with a weapon discharged when they believe that the suspect is still armed. Therefore, by having a weapon out, that was still a part of the standard procedure. And although Mr. McDonald was injured and stumbling slowly, he was advancing nonetheless. And as the court explained in Boyle v. Zari, for example, a suspect or a police officer's use of deadly force is unreasonable only when the suspect is unable to get up or otherwise defend himself. To be able to use a gun, Mr. McDonald was still up and could raise his arm towards the officers. Therefore, he posed an immediate threat.
No, I'm not following. It's okay to consider the dispatch, the contents of the dispatch, even though that dispatch was not at the moment of the threat?
I see my time has concluded. May I briefly answer your questions? That would be still considered in the moment of threat analysis because
Even though the dispatch was,
Right at-
what was the time differential?
it was right at the moment when they were entering the alleyway when Mr. McDonald appeared from out from behind the dumpster. Thank you.
One question before you sit down. We all know and heard of occasions where officers may have made poor decision-making in their actions. The moment of threat may shield them from being held responsible for poor decision-making unless we consider the totality of the circumstances. How do we get around poor decision-making in the moment of threat?
Your Honor, while it leaves out the officer's actions prior to the moment deadly force was actually employed, it also leaves out actions of the suspect prior to the moment force was used. Therefore, it balances the government's interest against the individual's interest leading up to that actual use of force. So therefore, by balancing those interests, even under the moment of threat test, both officers' use of force would be found reasonable. Thank you.
Thank you.
Thank you.
Okay, now Mr. Miltenberger.
Good evening, Your Honors, and may it please the court. My name is Braxton Miltenberger, and I represent the respondent, Sheila McDonald, bringing suit on behalf of her deceased son, Christopher. Under this court's existing precedent in both Graham and Garner, the excessive use of force by police is a seizure that is subject to the Fourth Amendment objective standard of reasonableness. However, under a totality of the circumstances analysis, and given the facts in this case, both officers Aziz and Fletcher engaged in unreasonable uses of force when they encountered Christopher McDonald.
No, wait a second here. Officer Aziz was shot,
That's correct, Your Honor.
and then she returned fire, right?
That is correct, Your Honor.
How can that be unreasonable?
Well, Your Honor, under Johnson v. City of Philadelphia from the Third Circuit, when you're conducting a totality of the circumstances analysis, courts must consider...
Isn't using a deadly weapon at any time?
It is, Your Honor, and even if this court were to find that Officer Aziz's use of force was reasonable, under a consideration of the totality of the circumstances, there are still genuine disputes of material fact that would preclude summary judgment. As Johnson v. City of Philadelphia held, a totality...
I think you ought to move on to Mr. Fletcher.
Excuse me, Your Honor?
I think you ought to move on to Officer Fletcher.
Okay, yes, Your Honor. When Officer Fletcher encountered Mr. McDonald, he engaged in an unreasonable use of deadly force. As Torres v. City of Madeira has held from the Ninth Circuit, when a use of deadly force relies on a mistake of fact, The analysis for reasonableness requires whether or not that officer could have reasonably perceived that the fact was mistaken. And here, the important mistake of fact is that Christopher McDonald was not armed when he was shot. Officer Fletcher says that Mr. McDonald was holding a metallic object. Officer Williams, in her affidavit, conclusively stated she was able to see from the distance that McDonald was holding a cell phone and not a firearm. Given that we are here on summary judgment, as this court has previously held in Anderson v. Liberty Lobby, summary judgment requires inferences of fact to be drawn in the favor of the non-moving party, in this case, my client. Given the fact that Officer Williams was able to tell that Mr. McDonald was holding a cell phone and not a gun, we must infer that although the alley, as both officers claim, was dimly lit, there was enough light for a reasonable officer to tell that Mr. McDonald was not holding a firearm.
And where was she vis-a-vis her partner, Officer Fletcher?
Your Honor, the record does not specifically indicate where Officer Williams was standing, but we know from the record that they were both in the alleyway near each other at the time that the fatal shot was fired. Now, whether that was 6 inches away or 1 foot away, the record is unclear.
Do we know who entered the alley first?
They entered together with their weapons drawn and a canine at the ready, Your Honor.
And who's holding the canine?
Officer Williams, Your Honor.
Okay, so she's focused on the dog and the suspect.
Your Honor.
Controlling the dog and the suspect.
Yes, Your Honor, that is true. All the more reason that it is impressive that she was able to conclusively conclude that Mr. McDonald was not armed. Further, it is worthy of consideration under the totality of circumstances that Mr. McDonald fired his weapon at Officer Aziz earlier that evening. But as the Fourth Circuit articulated in Harris v. Pittman, a reasonable justification for a deadly use of force can expire if material facts change, given the circumstances that officers are confronted with. And here, importantly, there were 2 material facts that changed between Christopher McDonald's engagement with Officer Aziz and his engagement with Officer Fletcher. Number 1 is the fact that when the officers entered the alleyway, they observed that Mr. McDonald's firearm was on the ground. The important material fact being that Mr. McDonald is no longer armed with the gun that he used to fire at Officer Aziz.
Maybe.
Yes, maybe, Your Honor.
They're
but
confronting a suspect who just shot a cop.
this is true, but Your Honor, Officer Fletcher, aside from the use of deadly force by Officer Aziz earlier in the night, Officer Fletcher had no reason to assume that Mr. McDonald was carrying a second gun. There was no indication that Mr. McDonald had 2 guns. It was not reported to Officer Fletcher.
Right, but we don't hold officers in the field to a standard of perfect perception. That's the 20/20 hindsight principle from Graham.
Yes.
The standard is flexible and contextual and has ample room for reasonable mistakes, leaves ample room for reasonable mistakes, even when we're not moving into qualified immunity territory. The actual Fourth Amendment standard leaves lots of room for reasonable mistakes. And why isn't this a reasonable mistake, given what was known to both officers? The fact that one officer correctly perceived what the suspect was holding doesn't mean that it was unreasonable for the other officer to draw an opposite inference.
Your Honor, that is correct, but under a totality of the circumstances analysis, the reasonableness of Officer Fletcher's perception is not limited to just whether or not Mr. McDonald was holding a gun. As we've covered.
I thought that was your argument, that he made a mistake.
You are correct, Your Honor, I misspoke. As we know under Graham, when officers are engaging in a use of deadly force under the totality of the circumstances, there can be consideration of the fact that Mr. McDonald was surrendering as he was coming out of the alleyway. When the officers entered the alleyway, they entered with their guns drawn and they called out for Mr. McDonald to reveal himself. When they initially entered, he was hiding behind a dumpster.
So he can assume that he was surrendering?
Your Honor, it would be incorrect to fully assume that he was surrendering, but given the totality of the circumstances, Mr. McDonald was complying with the officer's
And
commands.
where does the temporal line begin at the totality of the circumstances? Does it begin when the officer found out that Officer Aziz was shot?
In the case of Officer Fletcher, Your Honor, the totality of circumstances, it would include that the knowledge that Officer Aziz had been shot. The clock, so to speak, would begin running for Mr. Fletcher as he arrives on scene, but it would include information that he received over the radio.
It also includes Officer Williams saying to your client's son, drop it. And instead of dropping what was in his hand, he held it in his hand, raised it to his head, and continued moving toward the officers, correct?
That is correct, Your Honor. When Officer Williams ordered drop it, Mr. McDonald replied by saying, I have to say goodbye. Although it is worthy of note and would be considered under totality of the circumstances that when the officers entered the alleyway, they both confirmed that they heard a cell phone ringing. So there was at least some notice that a cell phone was in Mr. McDonald's possession. And regardless of the test that this court ultimately settles on, there are genuine disputes of material fact in this case that preclude the district court's grant of summary judgment to petitioners. The most important dispute of material fact is the fact that we have a testimonial discrepancy between the two officers that were on scene when the fatal shot was fired. As a State of Smart v. Wichita held in the 10th Circuit, when you have a testimonial discrepancy between two officers that rises to the level of a credibility determination, those determinations are ill-suited to summary judgment. They are best left to a jury. And that is what we have here. We have one officer, Officer Williams, who is able to conclusively state that McDonald was not holding a firearm. And we have another officer, Officer Fletcher, who says that Mr. McDonald was holding something. Mr. Fletcher was not certain that it was a gun, was not certain that it was a firearm, but was certain that something was being held. The fact that this discrepancy exists is enough of a genuine dispute of material fact to warrant this case surviving summary judgment and going to a fact finder.
Counsel, that the question is whether he was or was not armed. And the question isn't whether he was or was not armed. The question is whether a reasonable officer, knowing what Officer Fletcher knew at the time, based on the totality of the circumstances, could within the confines of the Fourth Amendment, draw the inference that he might be armed, based on the facts that he knew. Is that a reasonable inference under the circumstances such that his actions were reasonable under the circumstances? A jury wouldn't have to resolve whether it was a gun or not a gun. We know it was not a gun. It's a question of inferences. And why wouldn't that inference be reasonable based on what was known to him?
I see my time is up. May I respond?
Please.
That inference would not be reasonable because under the totality of the circumstances here, we have a subject, Mr. McDonald, who is visibly wounded, as both officers confirm. He is shot twice. His clothes are bloody. And as he is following the officer's commands and revealing himself in the alleyway, the officers already know, moving in, that Mr. McDonald's gun is located on the ground behind him. Under the totality of these circumstances taken together, it was not reasonable for Officer Fletcher to believe that there was an imminent threat to his life or to Officer Williams' life. Thank you.
One question, Mr. Biltenberger.
Yes, Your Honor.
In my previous legal career, I was a trial judge. And of course, we have to instruct the jury. And if I instruct the jury that they're to consider the totality of the circumstances. Now, these are just lay people, good citizens going back to the jury room. They're going to say, what does he mean by totality of the circumstances? So they write on a piece of paper, Judge, what do you mean by totality of circumstances? How do I answer that question?
Of course, Your Honor, the determination would ultimately be for the trial judge, but the response to that question for a juror would be that the totality of the circumstances is the end result of every factor known to the officers and known to the suspect, from the beginning of the interaction with police to the end of the use of deadly force. Everything that falls within those parameters, any fact, whether it's situational, whether it's environmental, whether it's information that the officers have in their heads, all of those things taken together would amount to the totality of circumstances.
So in the moment of threat, the officer is supposed to be thinking of all of that stuff as well.
Your Honor, in the moment of threat, the officer should be giving consideration to a fact like hearing a cell phone ring and knowing that the suspect's firearm is on the ground behind you. Those would be facts that should be considered by an officer in the moment of threat.
Okay, thank you.
Thank you. Ms. Rutledge.
Your Honors, I have 2 brief points on rebuttal. First, as the respondent says, in Officer Fletcher's encounter with Mr. McDonald was not armed. But hindsight of actual danger is irrelevant. Several courts have interpreted the language from Graham, such as the Fourth Circuit in Anderson v. Russell, where an officer's use of deadly force was found to be reasonable, even though the suspect was reaching for a Walkman radio and not actually a firearm. Second, Mr. McDonald made no efforts to surrender. It was not clear from his actions that he verbally or physically was surrendering. He continued to move and advance towards the officers and raise the object in his hands in an upward motion. In fact, Officer Williams stated to drop it, and Mr. McDonald did not drop the object in his hand. This suggested that he was not complying with all of the officer's commands in that moment. Additionally, his continued motions would raise serious and grave suspicions about the suspect's intent at that moment where a reasonable officer would have to act. Additionally, even looking at the broader circumstances in which Officer Fletcher ultimately decided to use deadly force, Mr. McDonald expressed a manifested intent to escape and a willingness to kill to succeed. Therefore, both Officer Aziz and Officer Fletcher acted reasonably in their respective uses of deadly force. To hold otherwise would be to ignore the principle that officers on the beat are not afforded the luxury of armchair reflection. Therefore, we ask this court to reverse the judgment of the 14th Circuit Court of Appeals. Thank you.
Thank you. Thank you. Our thanks to all counsel. We'll take the case under advisement and the court will be in recess.
All rise. All right, I guess we're in recess. There should be refreshments outside.
Please be seated.
All right, first of all, congratulations to all the competitors. This was an excellent competition and a great set of arguments, and we'll have a little bit more to say about that in a moment, but I do not want to keep you in suspense about the winners, so I'll get right to the main event here. And this panel of judges has concluded that the two winners of the Sherman Minton Moot Court Competition of 2025 are Lily Rutledge and Laura Stancato. Take a deep breath, everybody. You've worked very, very hard. That came through loud and clear in both the case materials that you provided to us. A lot of hard work and time and attention went into these materials to produce an interesting case problem. Thank goodness it wasn't ERISA. I've done a moot court that was an ERISA problem, and I opened this one up and said, oh, good, it's not ERISA. Fourth Amendment, I think I can track with that. So it was a very thoughtful problem, very interesting case problem, and superb arguments, really excellent arguments all around. It was a very hard decision. You all knew your stuff substantively. You were very poised, very in command of the material, both factual and legal, that had been provided to you in this case problem, and very professional. Took adversity well, came back from adversity when you encountered it, and got right to the important points of your argument, and that's really important in oral argument. And so we were thoroughly impressed with all four of you. I just want to say a few things as the appellate judge on the panel. I've been doing appellate judging now for 21 years on the Seventh Circuit Court of Appeals, and 5 years before that on the Wisconsin Supreme Court. So I've seen a lot of good lawyering. I've seen a lot of bad lawyering. I've seen a lot of acceptable lawyering at both levels. And your arguments were absolutely superb, better than much of what we see on a regular basis in the Seventh Circuit, and even occasionally at the Court of Last Resort, the Wisconsin Supreme Court, when I served many years ago. And so you should be very proud of yourselves. Your professors should be very proud of you as well. The law school should be very proud of you. You're every bit ready to come into real court and present real arguments based on the performances we saw today. So congratulations to all of you. I think what was clear is that you've all internalized the reality that that oral argument is not a speech. It's not a performance. It's really a dialogue with the court. So when you come into a real appellate courtroom or a trial courtroom, when you're arguing to a judge as opposed to a jury, two different kinds of argumentation, very different skill sets, very different objectives and goals. But when you're arguing to a judge, what's important is mostly the substance of what you're saying, and then also the way that you say it, your confidence in your argument, your poise and professionalism before the bench, and your ability to be nimble on your feet, to think on your feet, and to respond and engage with the court and the court's questions. And that includes some of the left field stuff that we threw at you, including cutting you off, move on to your next argument, counsel. We're not interested in that one. That happens with regularity in real court, and you have to be able to leave it on your notepad and move on to the next argument. And you also have to be prepared to engage with questions that drill down into the reasons behind the argument that you're making. You're looking for the win. when you're at the podium. You want to win your case for your client, but it's really helpful to step back and try to think about your case the way that the bench thinks about your case. And on the Court of Appeals, and to a lesser degree in the trial court too, we're not just focused on the result that we're going to deliver for one side or the other. We're really looking for a discussion, a dialogue about the reasons behind the rule that you're advocating for. Not just a statement of the rule. We definitely want to know the statement of the rule so that we can assess the scope of the rule that you're asking for. And that was one of the very interesting aspects of this particular problem. What is the scope of the rule you're asking for? How is it stated? How is it applied? Let's ask some hypotheticals, et cetera. And that's what made this an interesting problem for a competition like this one. But that happens with regularity in routine arguments before appellate courts, because we have to decide your case, but we also have to situate it within the broader trajectory of the development of the law. And that means we have to do some big picture thinking about where your case fits in that broader trajectory of the development of the law and the doctrine. And if we have to do that thinking, that means you have to do that thinking too before you come into court, to be able to give us, who have to write the decision, the right inputs, and so that we can test both the premises of your argument, factual and legal, and the consequences of your argument, factual and legal. And that means you have to be prepared for questions like the one that I kept coming back to. Does that rule make any sense? Because ultimately we have to justify the rule that we're writing for the communities that it applies to. And so you have to think about those. And just one example that used to occur with regularity in the Seventh Circuit when Judge Posner was presiding, famous big picture thinker, brilliant judge, iconic judge on my court. He would ask a question of counsel, and if the attorney responded by citing a case or citing the rule statement from a case, he would cut him off at the knees, well, figuratively, and say, counsel, that's an appeal to authority. I'm looking for a reason. I want to know the reason for the rule that you're asking me to implement in this case. And so you have to do that big picture thinking when you come in, and you had done that in this case. It was a good problem to stimulate that kind of thinking, so whoever wrote it did a good job. And so with those general statements, I just offer my sincere congratulations to all of you. You're off to a very bright future in the law, and I look forward to seeing you come and argue in Chicago. So I will turn it over to my colleagues. Jim?
Also, I echo a lot of Judge Sykes' comments as well. You made it this far. You're finalists. You need to be proud of your accomplishment that you made final. Even though we had to select two, there's four of you up here who should be really, really proud of what you've done. As Judge Sykes said, it was a difficult decision, but that's what we do. We make difficult decisions all the time. It's always very gratifying to me when I participate in these types of exercises to see how hard you work at this and how smart you are and how well prepared you are. And it's gratifying to me to know that our legal profession is in good hands. As Judge Sykes was indicating, when you're arguing in front of a judge, it's different than a jury. But when you're arguing in front of a judge, whether Court of Appeals or a district court, you're having a conversation with the court. We don't want you to read your briefs to us. We've already read your briefs, okay? We know what you're saying in your briefs. We want to have a conversation with you going back and forth. And that's why you need to prepare and kind of anticipate what kind of questions you might get from judges. If you're arguing in front of the Supreme Court, you got 9 people up there interrupting you constantly. So you have to be prepared. And I think what makes you comfortable, not only in the courtroom, but really in everyday life, doing things, is your preparation. Would you ever give a speech or a talk to someone or a group of people without rehearsing it first? No, you wouldn't do that. You go over it 4 or 5 times until you're comfortable with what you're saying so you don't trip over your words. And that's what you do in a courtroom as well. You prepare. So when you're in the courtroom, you look comfortable and you're confident in what you're saying. And all of you did that today. It was just excellent. For 2Ls coming in here, you guys are off to a good start. And I congratulate all of you. It's been fun working with you all too.
Hi, everyone. Well done, everyone, and congratulations to everyone who participated. I'm just a trial court judge from Chicago. I do hear a lot of oral arguments, but let me tell you, I think what you did today is so much more stressful than anything you have to do in court. Like, seriously. As I was driving here, I remembered being at Duke Law School, my alma mater, and driving for our first moot court argument, and just how I was beside myself. I didn't sense any of that in any of the 4 of you. And I can tell you from experience 25 years later that it just gets easier and better the more you do this. And for trial court purposes, the one thing I'll leave you with, lately I've noticed this happening in court and with my family. They're on all fours. When I ask a question, sometimes lawyers in court and definitely members of my family are like, oh, you're right. And I'll say, no, that was literally a question. I don't know. Like, please tell me, right? So when you get a question from a judge, especially a judge at the trial court level, we're all figuring this out together. We don't have a fixed record. The lawyers are learning the facts as they go because they're doing discovery, and it's a work in progress. And there's a lot of stuff to which I don't know the answer yet, or maybe ever. So take the question, assume positive intent. When you get a judge's question, it doesn't mean she's with or against you. She probably just wants to know the answer. So anyway, what a privilege to be here with you two. Thank you very much.
Thank you. And thanks to all who participated in this competition, too. I think we have a lot of the competitors out in the audience, and thanks to all of you for participating.
All right, this concludes tonight's premiere events. And this concludes it even more. Thank you all so much for coming. I redouble all the thank yous I gave at the top and say them doubly so. Thank you to all the staff, all the faculty, to our esteemed panelists, to the competitors, all the other students that helped make this event happen, today happen. Thank you so much. For those of you who will be attending the dinner, we'll be heading up there shortly. And for those of you who don't know what that's about, forget you heard that. Everybody, please have a wonderful evening, have a wonderful weekend, and thank you so much for being here.